This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
Todd Lutsky from the law firm of Cushing & Dolan now joins us here. And he's here for Ask Todd, which is your chance to ask Todd your estate planning questions. And he'll answer them live on air, actually. Yes, that's right. He'll answer them live on air. Phone lines are wide open at 888-205-2263. That's the number to call to ask Todd your estate planning questions. Again, 888-205-2263. We can usually get through 2 or 3 of these puppies. So get on the horn and give us a call so that you can chat with Todd. Again, 888-205-2263 is the number. Mr. Lutsky, how's it going today?
You know, it's going never better. How are you doing?
Good.
Oh.
Came across something interesting the other day, though.
You always do.
Found a guy kayaking in my attic yesterday.
Kayaking in your attic?
Yeah, it turns out he was a ceiling rafter.
Oh, yeah.
Yeah.
I guess so.
Yeah, I wasn't expecting
No.
that. Todd, want to talk a little bit about irrevocable trusts. I know we've talked a lot about life estates the last couple weeks, and quite honestly, kind of tired of talking about them. I can't do life estates anymore.
Okay, go ahead. I'm going to let you take this one away.
So I'm gonna talk about kind of the other option that a lot of people consider instead of a life estate. Irrevocable trust. How much does the use of an irrevocable trust to protect an asset impact your day-to-day life versus a life estate? See, I brought it back to the life estate.
You did, and I'm going to connect the two for you, but thank you for that. So, you know, one of the things we talk about in this guide is the right way and the wrong way to do a life estate. But if you're going to do a life estate, I'll call it the less bad way, would be to take the remainder interest of a piece of property and give it to an irrevocable trust.
Okay.
See, connecting the two here. Put it in an irrevocable trust. So if there are like 3 times in my guide that I recommend when you should use a life estate. And when you're going to use any of those 3 times involve an irrevocable trust. And folks, I think the great analogy and the question is spot on in the sense that what's the difference between just throwing the whole darn thing into an irrevocable trust versus a life estate? People think they give up control with a life estate, but think about how much control you give up with a life estate, right? So there's your compare and contrast. When you put the property in the hands of a child, you know, you're going to have trouble selling it without their permission. You're going to have adverse capital gains tax consequences because the kids are going to get a big chunk of the money if they do agree to sell it. They don't get a capital gains exclusion when you go to sell the property because they don't live there. You know, again, back to the hoping you even get their permission to do it. And the biggest problem is you didn't get much of the money because there's an allocation based on your age that a large portion, depending on how old you are, goes to the kids. So now you don't even have the money you need to buy another house if you sell your house. So to me, when you think about irrevocable trusts and the word control, I would say with a life estate, if I'm not using an irrevocable trust, I've given up way more control than I would give up if I used an irrevocable trust. Because with an irrevocable trust, I put the remainder interest in their kid's name is not on the property. There's no completed gift. I don't need anyone's permission to sell the property. You still control the trustee. You still control the ability to sell it. You have no adverse capital gains tax when you go to sell it when it's in a grantor irrevocable trust. You get your entire capital gains exclusion offsetting the entire gain or a portion of the gain depending on how large it is. So there's no adverse tax consequences. And maybe most importantly, all the money is available to buy another house because most of it is in the irrevocable trust. And it doesn't even restart the 5-year waiting period. And your kids don't have there's no creditor issues with your kids getting divorced while you're alive. So great question, Chuck, and I hope you see the difference between life estates alone and irrevocable trusts.
Talking with Todd Lutsky from Cushing and Dolan. Still room on the phone lines at 888-205-2263. That is the number to call for your estate planning questions live with Todd right now. 888-205-2263. We're going to take a quick break here, but when we come back, we're going to get to those questions for Todd. Again, that phone number is 888-205-2263. And again, only have space for a couple. So one more time, that number is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Todd Lutsky answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. Reminder, if you've got questions for Todd, this is your chance to ask them live on air. 888-205-2263. We do still have a little bit of room on the phone lines here. So please get calling at 888-205-2263 to ask Todd your estate planning questions. Let's go first to Sean in Monson. Sean, what is your question for Todd?
Good morning, Todd, and good morning. I very much enjoyed, Todd, listening to your advice on this program.
Well,
my question to you is: I've been advised at one point to get a Medicare trust to protect our property from the nursing home.
Okay.
And I'm wondering, I hear you talk about irrevocable trusts very frequently, and I'm wondering, does the irrevocable cover in a Medicare situation, or can it, or are they two different things?
No, so yeah, you're right about the fact that you're saying you're kind of saying a Medicare trust when in reality what I think you're saying is, and there's no such a term, but Medicaid is what you're thinking about. I know they use the term so closely. Medicaid is what you want to be able to apply for when you're in a nursing home. And when you're in a nursing home, if the assets are in an irrevocable trust, and remember that, folks, there are many kinds of irrevocable trusts, and we do talk about different kinds of irrevocable trust, but we tend to spend a little more time, and you're right about this, on irrevocable Medicaid trusts. And yes, they are absolutely designed to protect assets from the cost of long-term care. In other words, you would take your home and quite frankly, maybe some of your other assets, depending on, what they are and whether it makes sense to put them in there, like money, investment portfolios. Now not qualified plan money, but other money into the trust. And then, 5 years from the time that you do this, if you get sick after that, you or your spouse get sick after that, then these assets that you put in there are like you don't own them. It looks to the nursing home like they're not yours. And then they would be, not available. When I say protected, I mean not available for the nursing home, not available to make you ineligible for Medicaid benefits or ineligible for the state to help pay for the nursing home costs. So you're spot on. These are the kinds of trusts that we talk about that will protect the asset from the cost of long-term care. And depending on the size of your estate, I think it probably makes sense for you to, sit down with an attorney and that does this and learn in more detail than I can give you on the radio how, in fact, they work and how much control you can keep and how you really, I can just tell you that they won't really disrupt your life, at all. And you'll still get this protection from the nursing home and avoidance of probate and, depending on the size of your estate, even a reduction from your Massachusetts estate tax liability. So hopefully that helps a little, and thanks for the kind words earlier. Folks, this approach, this irrevocable approach that we just talked about, I think might be better than the life estate, but a lot of people have them. They're not horrible. They do work. They do have benefits. There are pros and cons to life estates, but a lot of people have them, and that's why we did this guide, calculating the consequences of a life estate. Why? Because people have them, and it seems to be a quick fix. Not always great. Again, pros and cons. How much control do I give up? What can I do after I have it? Can I change my mind as to who gets it? Can I sell? Can I buy another house? What are the capital gains tax consequences? Folks, if you've got one of these life estates, call and get the guide and learn what you actually have. If you're thinking about getting one, call and get the guide so you can find out what they are before you decide to get one, and finally, how best to do them and when to do them. 866-848-5699 or legalexchangeshow.com. You can download the guide right there. Again, 866-848-5699 or legalexchangeshow.com. Or for more information, please go to our Instagram page, Cushing Dolan PC.
Todd, I got another one for you here. Let's go to Stacy in Peabody. Stacy, what is your question for Todd?
Hi, I have a question. So a parent died with property in a life estate, only gave it to one child.
Oh.
So that child wants to sell it but share the proceeds with their sibling.
Oh, now how nice is that?
Yeah. So what are the consequences for, like, tax implications for maybe even gift taxes or capital gains?
So great question. So let's explore this a little bit, because I think it's good for everybody else as well, Stacy, to learn what was done here. So the parents actually were able to create this life estate arrangement where they took the property and they deeded it to child number one. And let's say there's 3 children. Deeded it to child number one. That's how they created it, and they reserved the right to live there. Now, we say there's a lot of negatives to this. Well, in this case, if 5 years had gone by, it actually protected it from the nursing home, as you folks may or may not have found out if your parent ever needed nursing home care. So that would have been plus. It is now going to avoid probate, so you should be finding that out right now. So that's a plus on this side. And I think the last piece, which goes to your point, Stacy, is it would have received a full step up in basis. So even though they gave away the property to one child and reserved the right to live there, now the full value of that property is includable in the estate for estate tax purposes. And provided the value of that property plus the other assets that they might have doesn't exceed $2 million, now there's no estate tax due, at least not en masse. And the child, in this case child number one, received the property with a full step up in cost basis. And this is what goes to your point. Well, now the child wants to sell the property. So the child is automatically vested in 100% of the property the moment the parent died. That's another benefit of a life estate. But you're right, to the exclusion of the other children. So not entirely sure why mom would have wanted to disinherit or dad would have wanted to disinherit the other kids. But in effect, that's what was done. Nice part here, though, is we've got siblings who get along. Always so nice to see that. So in this case, can the child sell the property? Yes. Can the child then give money to the siblings? Yes, again. So what's the ramifications? One, child sells the property. Because of the full step up in basis, 0 capital gains tax, provided it's sold, within 9 months or a year from the date of death. There shouldn't be much growth from the time you die until the time it's sold. So now all the money is preserved. We don't have to deplete any of the money by paying taxes. Now what? Now he's got all this money. Let's say it's $1 million. And we've got 3 kids, and we got to give, $333,000 to the other 2 kids. Well, that's a $666,000 gift that this one child needs to make to the other 2 kids. That is a taxable gift to who? To the child making the gift, because the parents didn't design this plan, better to prevent this from happening. So, yes, it's a taxable gift to the giver, not to you, Stacy, not to your siblings. You just simply get the dough, tax-free, income tax-free, gift tax-free. Now, will your sibling have to pay a gift tax? Well, they'll have to file a gift tax return, but Good news is they won't have to pay a gift tax. There is no gift tax in Mass. There's a federal gift tax, but you have a $15 million gift tax exemption. But you got to file and eat into that exemption a little bit to use up some of that exemption. So at least you can do it. And in this case, we're kind of dodging some bullets, and we're not going to end up being out of pocket anything. But he is going to eat into his estate tax and gift tax exemption. So thank you.
Mr. Lutsky, thank you so much for joining us today. We really appreciate it.
Always a pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.